And Liz, remind me again. Oh, here it is. Never mind.
Okay.
I'm recording to the cloud. Right, Liz?
Correct.
Yeah.
Yes,
Okay.
correct.
All right.
Okay. The Court of Appeals for the 8th District of Texas is now in session.
Thank you. Mr. Walker, you're representing the appellants, is that correct?
That's correct, Your Honor.
Okay, and Mr. Baruch is representing the appellees.
Correct, Your Honor. Thank you.
Okay, there you go. And so the court calls case number 08-20-00138-CV, and this is Busby and the Busby Law Firm versus Roberto Canales and Roberto Canales, MDPA from El Paso. Okay, and Mr. Walker, you may proceed. Before you start, just to be sure, you see the timer?
I do. That's why I put my glasses on so I could see a little bit better.
All right. Well, and as you well know, I know both of you have argued before us before, but obviously there's green, yellow, and red means stop. So just a reminder. But you may.
By Busby concerning looking for information about him and his medical practice, Dr. Canales promptly proceeded to file a lawsuit with an improper primary purpose. That is, to stop the speech well before the adjudication of whether any of the speech was defamatory. Now, first he sought to do that by seeking an ex parte temporary restraining order to be followed by additional injunctive relief. Now, even though the U.S. Supreme Court has never in over 200 years of jurisprudence upheld a prior restraint on speech in a defamation case, the trial court nevertheless granted the ex parte temporary restraining order. After some weeks of litigation, the trial court also dissolved the illegal TRO and then finally denied the motion to dismiss that we filed under the TCPA without specifying the reasons. Now, this, of course, leads us to this interlocutory appeal. So at this point, the court has four principal questions to answer. First, did Busby demonstrate that Dr. Canales' lawsuit for defamation and for business disparagement was it based on or in response to the newspaper and social media advertising that was used to obtain information on a matter of public concern, namely the quality of medical services that Dr. Canales provided? Second, did Dr. Canales demonstrate that the commercial speech exemption of the TCPA applied in this case to bring it outside the scope of the TCPA, even though the advertisements were investigative, that they are non-commercial and simply sought information about Dr. Canales and his practice? Third, did Dr. Canales meet his shifted burden of proof to demonstrate by clear and specific evidence a prima facie case on each element of all of his causes of action, despite the fact that they never identified an actual statement of fact, that he identified no objectively verifiable facts that he claimed were defamatory and never identified any proof of damages? And fourth, did Busby meet his burden to demonstrate that he was investigating claims, in fact, and that at least one patient died while under the care of Dr. Canales, so that Busby could invoke the affirmative defense of truth to the claims for defamation, business disparagement? So we submit that the court should find that Busby met his burdens of proof while Canales did not, and that lawyer non-commercial investigative communication that shows up as advertising does not fall within the limited scope of the commercial speech exemption of the TCPA. And for that, we ask the court to reverse the trial court and order dismissal of Dr. Canales' claim. So the first question ought to be fairly straightforward to answer. In other words, did Busby meet his burden of proof to show that the TCPA applied? Now, one point of clarification I want to make is that when I refer to Busby, I refer to both Mr. Busby individually and to his law firm. Now, of course, we have an issue on this appeal that there was no reason why Mr. Busby was sued individually, and we may get to that if we have time later. But there's no question in this case that this is a legal action that there were communications and that they were based on or in response to these communications by Busby. So the only question initially is whether the communications themselves were on matters of public concern. This also shouldn't delay us very long in answering the affirmative, because it's very well settled since Lippincott in 2015 said that the provision of medical services by a healthcare professional constitutes a matter of public concern. Of course, the statutory definition of matter of public concern has changed somewhat. It no longer lists the several factors, but it is still as defined. And again, using the legislature didn't change this very broad nexus language of the speeches in connection with and regarding. So these are just still what the Supreme Court told us in the Coleman case, that that there's not much of a nexus requirement between the speech and the matter of public concern. Here, it's actually a very close connection, and so we already have guidance from the Supreme Court as to what is a matter of public concern, namely providing medical services by a healthcare professional. There's no issue here about whether communications are in private. It couldn't be more public, I think, in that the communications, the advertising for information occurred in newspapers, social media, and was eventually picked up. And the fact that the issues involved are a matter of public concern, the court could frankly take judicial notice of the reporting that's occurred over the course of last summer after the lawsuit against Dr. Canales was filed, about how it was picked up and reported El Paso Inc., various other media outlets as well. And this is also not a case about goods and services. It's just about the providing of healthcare services by Dr. Canales. So that really should get us past the first question. First question is, yes, Busby met his burden to demonstrate that the TCPA applies because of speech on a matter of public concern. Now, the courts talked before about the burden shifting, and normally we would take a look at the burden then shifting to Dr. Canales to prove by clear and specific evidence the prima facie case. But I think a question that the courts want to get to earlier is whether the commercial speech exemption applies. Now, the court in the Miller-Weisbrod case, now approaching 7 years ago, as time is flying, looked for some guidance to cases that interpret the disciplinary rules of professional conduct as it should. And so we know that commercial speech is regulated under the disciplinary rules, but the disciplinary rules make it clear that that the scope of that regulation only applies to commercial speech, and it won't apply to non-commercial speech. So in other words, we know that some speech by lawyers is commercial and some is not. The scope of the disciplinary rules applies only to commercial speech. Now, what we've seen is in the briefing from Dr. Canales, the position that they have taken is doesn't make this distinction between commercial and non-commercial speech. They keep wielding a phrase from this court's opinion, the Miller-Weisbrod case, about lawyer advertising as commercial speech to read in all at the beginning of that sentence. I think that's unfair to the court, and this phrase has been misinterpreted and overapplied. Certainly, this court did not mean to suggest that no advertising by lawyers could ever be non-commercial speech, regardless of the type. The scope of the commercial speech under the common law and pursuant to the disciplinary rules, it does include advertising. Now, one of the problems we get into is when we talk about advertising, a lot of us tend to kind of think about advertising as being of one type only for some sort of profit, for commercial purposes. And when we talk about lawyer advertising, we have to be careful in that use. It's kind of like, it's interpreting the advertising to include nothing but commercial advertising. It's kind of like saying we're talking about global warming when people are complaining about what humans do. they use the term global warming without referring to anthropogenic or human-caused global warming. We need to distinguish between natural versus human caused. And the same is true with respect to the term lawyer advertising. So if lawyer advertising is used as a shorthand for commercial advertising, that's okay so long as we can just say that in the context. But in this case, the advertising in question simply is not for obtaining or soliciting professional employment, which is where the bar regulation would apply. Now,
Counsel, if I could interrupt you, because I think you're kind of getting to the core of my problem in this case. The text of the emails and Facebook and whatever itself says, we are investigating claims for parents whose children plural, died while undergoing treatment by Dr. Canales and the hospitals with whom he is affiliated. Yet your client only represented one set of parents and one child and one hospital. So by virtue of using the plural there, doesn't that telegraph that what they're really doing is fishing for more cases and more clients? I mean, isn't there kind of an embedded fact question there? I mean, I know your client signed an affidavit that said he was only looking for witnesses, but at some point, can't you look at the advertisements themselves and say, okay, there's a fact question here, and I think they really were looking for more than just witnesses?
Your Honor, it's a great point and the first thing that we have to do, according to the Neely case, is look at the face of the advertisements. And we see in the face of advertisements, they don't contain the usual magic language. We can assist you, we can represent you, you may have a claim. And that's one thing we did. We were at pains to do to include in Mr. Busby's affidavit that they did not include any of that sort of magic language. The problem, and Mr. Busby had indicated in his affidavit that he found it useful in some other cases to advertise to try to find people who would have knowledge. Well, as we all know, you can't, if you were to place an ad or communicate in which the only thing that you did was say, we are looking for witnesses about a practice, most people interpret the term witness to mean eyewitness. And so what you're doing with this advertisement and making a plural of child to children and claims is you have to use language in the broadest sense that you can to communicate with people that it's okay for them to contact you, even if it wasn't their child or they did not actually eyewitness certain conduct. I think that's the issue here is, how do you, when you're this is not an area where you see a lot of it, but it does occur. And so, for example, the Florida bar has said that when you're already representing somebody and you're advertising for information, that is not commercial speech. That's not subject to regulation. I think they have it right here. So here,
let me just ask you, Mr. Walker, don't you think it would have been probably, I'm thinking we wouldn't even be here if Mr. Busby had perhaps asked, not as specific a question and made something more general about if you have, we are surveying your experience with Dr. Canales. Please contact our office about your experience as a patient or a parent of a patient. I mean, as opposed to specifically asking for people who have experienced the death or a seriously injured child to contact their office, because quite frankly, it looks like a pretext for fishing for new clients. Don't you think?
I respectfully disagree, Judge, because it's the problem that you run into is exactly what language is going to be most effective. I don't know. I don't think anybody here is going to be able to identify what is the most effective language to capture the attention of people who can shed light on the information about the services provided by Dr. Canales. Now we know, of course, that on this issue, and I have to again go back to the fact that Dr. Canales bears the burden of proving that the exemption applies. So Dr. Canales did not avail himself of any of the quick discovery procedures available under the TCPA to take a deposition, for example. What is this aimed at? What is this geared towards? Is there some other language that was considered or something of that nature to dive deeper into that?
Counsel, if I could interrupt you again, I mean, doesn't it also kind of go beyond just the language? I mean, there's like a picture in one of these, a very unflattering picture of what looks like a doctor. I assume that that's not Dr. Canales. I don't know what he looks like, but it's not very flattering. And it talks about, did Dr. Canales kill or hurt your child? And I guess maybe what I'm really kind of getting to is our standard of review, in that I know we've said de novo, but can we have fact questions that are kind of built into this question of whether the commercial speech exemption applies, and do we owe any deference to the trial judge, who it sounded like from the bench she was struggling with the same question, and perhaps she's made an implied finding that this was phishing for clients.
Well, Your Honor, I think we're stuck with the de novo review, period. There's not a substantial evidence or any sort of deference that we're going to have to give to the trial court, especially the trial court doesn't make a finding. So we don't know why the trial court denied the motion to dismiss. All we know is that she did. And this, of course, followed the trial court granting an unconstitutional temporary restraining order. This is not an abuse of discretion standard that we're going to have to follow. So we have to take a look at it de novo, fresh, take a look at the language and the advertising. So I think that Dr. Canales found it distasteful. He found it offensive for whatever, whether you agree with him or disagree with him. And then he sought to try to stop that by using a prior restraint on speech. And so the fact that there is a character, some person who looks kind of like a doctor, and there's some questions asked, doesn't change our inquiry, which is whether on the face of it, does it propose a commercial transaction under the way that the bar looks at it, or under the disciplinary rules, under the Castleman factors, what is being communicated there. And so it doesn't ask, can we represent you? You may have a claim, anything of that nature. This is going into interpretation. I mean, in order to read a commercial transaction proposal on the face of these advertisements, you have to engage in various interpretations and not necessarily a reasonable person's interpretations. So under the TCPA exemption, unlike the bar Part 7 review, you can take a look at underlying information. You say, well, okay, so I'm not sure from the face of this that it proposes a commercial transaction or that it is aimed at obtaining additional clients. Let's go ask some other information. So that's why we have the only evidence on this question. And Mr. Busby's affidavit says we were not seeking additional clients. We already had a client. The reason we're doing this is to try to find out information about additional matters. As in fact, it turns out that it was very fruitful, and some of that information is included in the lawsuit that was later filed. So they may not like it. You and I may not have drawn up the Facebook ad in the same way, but this is an issue that is not dispositive of whether it is commercial speech under the TCPA. If you don't like it, if you don't like how it's communicated, that's not really relevant to the inquiry of does it fall within the commercial speech exemption. Again, that may not be our word choice, but in order to try to find people who have knowledge, I guess we've all done this. We've all been on committees. We've been on a variety of circumstances where we're providing input and language. And if we go through some committee, we sometimes come up with some better language that somebody didn't think of that might achieve the same objective. We can't do that here. All we can do is take a look at the speech and say, is this speech, is it directed to potential clients of Busbee in order to obtain professional employment by those people? And from the face of it, you can't say that. From the face of it, it says we are investigating. You look at, the initial ads, for example. And I'm limiting the discussion to the advertising that refers to Dr. Canales. If you look at those, they talk about we're investigating claims, and they were. They did. They did and do represent the Salcedos. They did, who did lose a 3-year-old girl while under the care of Dr. Canales, and they tried to obtain information that might shed light on, is this an isolated incident? As Mr. Busbee said in his affidavit, before they began the advertising for additional information, they knew that there were some other issues. They were aware of other problems before they began the advertisement, and so these ads, which are
let me just ask you. So when they say they're investigating claims, which indicates more than one claim, and when you say they knew there were other issues, are you saying that they knew there were other parties and possibly other claimants?
No, Your Honor. The South, if you want to be, again, we go to the language. Claim simply refers to the claims of the Salcedos, I think. But if you're trying to obtain information, in other words, and we know how it works. So if you're trying to find out from people, did your uncle or aunt or cousin or somebody else have an issue? We're investigating claims. Okay, so did some other people have claims? What happened to them? As there's been something that's been buried, it's difficult to get through whatever communication issues that people may have in order to elicit the information. I think taking depositions of people, we can all testify to how often you ask questions. If you ask questions about a witness, about a particular event, you may not get an answer, but when you start asking questions about other things, if you heard about, or if you have a relative or a friend who has experienced something, all of a sudden we find out more information. So that's what this is geared to do. Whether it's the most artful way to do so, I don't know.
So when you say that the advertisement is seeking this other information, and it's asking for the audience to express their own experience, I mean, I guess I need to understand a bit better of what was the information that was being sought, because it does seem as though they're trying to ask other parents if they have maybe a similar negative experience. How does it support the idea that it's just a matter of public concern?
Well, and here we kind of have to reach ahead a little bit, because matter of public concern regarding the quality of services. So for example, unfortunately, Dr. Canales took the approach that asking a question about whether a child had ever died or been injured in his care, suggested it had never happened. Well, he's been in practice for a long time. As a physician, he's going to lose a patient from time to time. But going beyond that, are there issues related to, is this a rare circumstance, or is this part of a pattern in practice? That's why you go into that information. That's why you want to find out, in certain types of cases, are there other claims or incidents, and are there issues that result in whether Dr. Canales should even be practicing medicine at the Children's Hospital, which was an issue that came up later in the lawsuit. And again, this is a matter of judicial notice. We did not have that on file at the time that this appeal started, but it's out there. And so, it's trying to find information on other experiences that are relevant to issues of the doctor's practice, potential punitive damages, the issues concerning whether he should be practicing or have privileges at that hospital. As it turns out, that there were administrative people who, after the advertising, came forward with affidavits and other testimony. So that's kind of hopefully that answers your question about what you're trying to do, because other information about other incidents may be relevant and may be admissible, maybe it's not, but that has to be determined at a later date. Does that assist?
Yes.
Okay, I see that I am coming short on time this initial part, but basically, we anticipated it would take a while to be talking about the language and in the advertisements, but I think that one thing that we need to do is make sure that the real issue here is Dr. Canales meet his burden of proving all of the elements of the Castleman test. In other words, that Busby was primarily involved in sales, not just providing services, but the Supreme Court in Castleman and in Harper have informed us better that we have to narrowly construe the exemption in order to make the statute work. Well after this court's decision, the Miller-Weisbrod case provided the 4 criteria that we're supposed to look at in determining whether the commercial speech exemption of the TCPA applies, and it has to apply to the communications about the defendant's own services, not about Dr. Canales' services. So, for example, here we're just talking about Dr. Canales' services in the ads and not about what Busby can or cannot do. I see that I am winding down to the last few seconds. Before we turn this over to Mr. Baruch, do you have any other questions I can answer now?
Yeah, your time you're actually over right now. So we'll go ahead and turn it over to Mr. Baruch. Thank you.
Thank you, Your Honor, and may it please the court. The only issue this court needs to reach is the applicability of the commercial speech exemption. And I think really the Busby firm's arguments flow from 2 false assumptions. The first, as counsel said, is this idea that there are some magic words necessary to constitute an advertisement for professional services. And the second is that the trial court somehow was obligated to accept Mr. Busby's self-serving testimony of his own intent. Both of those assumptions are incorrect. Let me start with the first. Was the trial court proper in concluding that these advertisements were seeking to entice clients? And there's something about these advertisements that nobody's really talked about, that I only came into this case about 2 weeks ago, but something about them that struck me immediately, which is that they all push the reader to the firm's website, something that nobody's really talked about. And that's important, I think. This was not a separate Canales investigation website. This was the Busby firm's advertising website. Okay, and there's no question, and counsel could not dispute, that that website is, even under what we view as the inapplicable disciplinary law he's relying on, constitutes an advertisement that falls under those rules. And I started thinking yesterday, I thought, well, how would all of us look at this case if the ads had said this? What if the ads had said, "Hi, I'm Tony Busby. I'm a lawyer. I file lawsuits in your community in El Paso. Take a look at this fancy website I've got. It's going to tell you all about my experience, all the amazing things I've done, the many awards and accolades I've received, my results in past cases, and it's going to explain how I can represent and help you with your particular case." I suspect none of us would be having this argument if the ads had said that. And my point would be the ads did say that. That's exactly what they said. They said, "We're the Busby law firm," unquestionably. They disclosed that we file lawsuits in El Paso because they're talking about one they have filed and talking about investigating claims there. And then they push the reader to a website. And the second you land on that website, on the home page, I want to get this just right, it says, "Sometimes your case is so important that you have to have experienced trial lawyers working for you. We are those lawyers, and we look forward to working with you to help you."
Is it your argument that the website then is within our record to review?
I think so. I mean, I think they put it within the record by pushing it there. But whether it is or whether it isn't, let's say this. It clearly pushes to a publicly available website. And that is not something you normally would do if you only were looking for witnesses. You wouldn't push to an advertising site. So I think that's an overlooked point. That alone to me would justify the trial court's decision. But I think the trial court made a second point that also has not been discussed so far today. And it was the language, and I'll turn to a minute to the other language, but there also is the language in these ads about, quote, part of a larger problem with Dr. Canales, end quote. And the trial court looked at that and said, well, I think a reasonable view from the reader's perspective would be, hey, the same thing happened to us. Let's call so they can represent us too. They're looking to see if there's a larger problem. So I think that language is important. And then finally, as we've already talked about today, there's the use of the plural, not once, but twice, right? We've got investigating claims in the plural for children in the plural. And as we all now know, at the time, the Busby firm was representing one child or representing the parents of one child and investigating one claim. And the trial court looked at that and said, I think that language makes it pretty clear they were anticipating signing up more clients as a result of these ads. They were already jumping ahead and using the plural. So I think when you bundle all of that up, the trial court's conclusion based on the language of the ads themselves is eminently defensible and is proper. What this really looks like is a too clever by half effort to execute an end run around the Miller-Weisbrod decision. I mean, this case is very similar to Miller-Weisbrod. I argued that case. The chief wrote the opinion in that case, and it's almost directly on point. And what they really look like they're doing here is trying to be a little bit clever in sneaking around Miller-Weisbrod. But they certainly didn't disclaim any intent to have additional clients. Those ads didn't say, you know, we are not taking new clients at this time, but we are seeking to investigate the one we have. There was no language like that. This appears on its face to be a solicitation. And, you know, I want to circle back to that and make a point about Miller-Weisbrod. But before I do, let me just very briefly address the Busby affidavit. Trial court was well within its rights to disregard that affidavit. Okay. This was at the first phase of a TCPA consideration. The trial court is the finder of fact in deciding applicability. And our newly amended section 27.006 refers to evidence that could be considered under the summary judgment rule. And it is well established under the summary judgment rule in Texas that a witness's self-serving testimony of his own intent is not competent summary judgment evidence. And I want to provide the court with an illustrative citation. There are many cases that say this, but one in particular, the Granger case at 930 Southwest 2nd 609 at 615 makes this point, that this is not competent summary judgment evidence. And as a result of that, the trial court was perfectly entitled to disregard it. And I think to elaborate a little bit on the question that was asked about the standard of review, there absolutely are some factual determinations. The overarching standard of review is the legal applicability of the TCPA, which is reviewed de novo. But as with any legal question requiring de novo review, there may be associated factual determinations, and witness credibility would be one of those. And I think counsel would have to agree with that. I mean, candidly, my leading authority for that is his own paper. If you look at his CLE paper on the TCPA website, which is posted on his firm's homepage, he makes this point precisely. He says, quote, the TCPA requires the trial court in the first phase of determining whether the action falls within the TCPA to be a fact finder and to weigh the evidence. Well, if that's the case, it's hard for me to understand how we could say that the trial court is the finder of fact and gets to weigh the evidence and make credibility determinations, but the Court of Appeals is going to review those de novo. That just wouldn't, we don't do that, to my knowledge, in any other area of the law. Those types of evidentiary weight questions and credibility questions, I think we would defer to the trial court. And here,
Counsel, let me just be sure, was there an objection to Mr. Busby's affidavit at the trial court?
not that I think there were some objections, but I don't think there was a ruling on them. So I don't think there's any issue with objections here. I think this would have been a case where the testimony was not necessarily objectionable. It was just no evidence, as we say in the summary judgment context, because it was a self-serving statement of his own intent.
But you're saying that under our de novo review, that pursuant to Granger, we don't have to consider the affidavit or that part of the affidavit that's self-serving.
I think that's right, Your Honor. Because and here, even if the affidavit is admissible, which it may well be, the trial court was entitled to weigh it against the language of the ad. And so the trial court may have said, okay, I'm going to admit it. I just don't attach any weight to it because I think it's a self-serving, uncontrovertible statement of intent. But the point I was going to circle back to about all this is really the case that this looks almost exactly like is the Cato case from Massachusetts. I mean, that's the same, what I call the too clever by half approach. That's the same approach. That case involved Jan Schliekman, who was the lawyer that John Travolta portrayed in a civil action. And what Mr. Schliekman did in that case was to create a website about a company he considered to be a bad environmental actor. And he didn't, same thing here, no language of solicitation, none of what counsel refers to as the magic words of solicitation. Mr. Schliekman put in an affidavit just like Mr. Busby saying, of course, I didn't intend to get any clients. This was a public service about a dangerous company. And the court in Massachusetts sort of looked at that and said, you've got to be kidding. We don't attach, and in fact, there's a line in the opinion that says we attach absolutely no weight to Mr. Schliekman's statement of his intent. This clearly was an advertisement for his legal services. And this court, the chief, in writing the Miller-Weisbrod opinion, cited Cato favorably. It's one of the leading cases in the country on commercial speech exemptions under these types of statutes. That seems to us to be exactly the case here as well. So with those, and by the way, I would also note, we can also look at the Fifth Circuit's decision in Moss and Bagby, and it's unclear what the specific language of the law firm's advertisements was there. The Fifth Circuit doesn't actually quote the language of the ads, but I think it's at least instructive in this regard. The Fifth Circuit resolved that case under the commercial speech exemption and held that the commercial speech exemption applied without feeling any need to cite the specific language at issue. So whether there were or were not magic words, the Fifth Circuit felt that was unimportant to its legal conclusion applying the commercial speech exemption. So with that in mind, I think, it becomes very clear under the Castleman test, because counsel's argument, the Busby firm's argument with respect to 3 of the 4 prongs presupposes a finding that they weren't seeking clients here. The only one that doesn't depend on that finding is the first element, which is, do lawyers sell their services? And that's a creative argument, but it's one that this court considered and rejected in the Miller-Weisbrod case. The Miller-Weisbrod firm made exactly the same argument that the Busby firm is making here, that they provide legal services. They don't sell legal services as their principal occupation. And this court made short work of that argument. Of course, lawyers sell their legal services the same way other professionals sell their services. It was not briefed in this case, but when I briefed the Miller-Weisbrod case, I pointed this court to numerous Texas statutes that refer to and regulate the selling of legal services by lawyers. And I think that led or explains this court's decision in Miller-Weisbrod. So that argument has been rejected, and there's been no intervening law on that in the interim by any court, much less this court or the Texas Supreme Court. The remaining 3 elements of Castleman are clearly met, assuming there is no predicate finding that these were not advertisements. Once you accept the trial court's conclusion that these advertisements sought to entice clients, the second, third, and fourth elements become pretty easy to resolve, right? Mr. Busby or the Busby firm made these advertisements in the context of its work as a seller of legal services. They arose out of a commercial transaction involving those legal services, and the intended audience were potential consumers. So all of the elements of Castleman are met. In our view, this is a pretty simple case under Miller-Weisbrod. The trial court permissibly concluded they were looking for additional clients. I think with respect to matter of public concern, I'm going to rest on the briefs, both because I don't have anything particularly intelligent to add to what was in the briefs, and also because we don't believe the court needs to reach that question. I will just say a couple of words about the prima facie case. Even if the commercial speech exemption did not apply, we believe Dr. Canales made a prima facie case as to defamation. We will concede the lack of any evidence on damages for business disparagement, but on defamation, this was defamatory per se in that it attacked Dr. Canales in his profession and therefore required no evidence of damages. And so that leaves us just with the elements of falsity and negligence. And here, their argument on falsity depends on their interpretation of the gist of the advertisements, right? Because the defamation claim depends first on a determination of what is the ad's gist. Ultimately, a jury is going to have to decide that. The jury will tell us what the gist is, but certainly one permissible view of the gist at this stage of the proceedings would be that the Busbee firm was alleging it had knowledge of multiple children who died on Dr. Canales' watch, and that he did something to cause that. He somehow caused the deaths of multiple children, and that they were investigating those deaths. And Mr. Busbee's affidavit makes clear that's untrue. That's untrue. They had one, that's all. So their argument really depends on their interpretation of gist as opposed to the permissible gists that might be attached to the ads. Now, again, they may convince the jury that their view of the gist is correct, but that is not the appropriate inquiry at this stage of the litigation. Right now, it would simply be, is there one permissible view of the gist under which Dr. Canales made a prima facie case of defamation? And here there would be. So,
Mr.
Yes,
Baruch, I just want to make sure that I understand your argument on the falsity element. So well, I know there's several ads, but one of the ads, I mean, where's the language in the advertisement itself that you're pointing to identify the falsity, or to say that there was a suggestion on the part of the Busbee firm that they had knowledge of more than one death?
We are investigating claims in the plural on behalf of parents in the plural involving children in the plural. We believe, again, a jury may view it differently, but certainly one reasonable view of that would be that the Busbee firm had multiple claims and knew of multiple children who had died on his watch. And I think also, as the members of this court have noted, you sort of juxtapose that with the nearly caricature type picture that was posted, and it rather clearly seems to suggest something terrible that Dr. Canales did to contribute to these deaths. So again, we don't think the court needs to reach that issue. This case is easily resolvable on the commercial speech exemption under Miller-Weisbrod, but if it does, there is enough there. A prima facie case is just that minimum quantum of evidence, and we believe it exists in this case. If the members of the court have no more questions, I'm going to cede the remainder of my time.
Thank you.
Thank you.
Rebuttal, Mr. Walker?
Thank you, Your Honor. To return to a question that Justice Palafox brought up about, whether information of the website itself is within the purview of the court, I'd say no. What we're talking about is a lawsuit. We're constrained by the facts of the lawsuit, and the Dr. Canales filed a lawsuit concerning certain advertisements that were taken out in social media and on the newspaper. They refer to a variety of they may refer to the website. The website itself is not part of the evidence. And so I respectfully disagree that that's to be considered. Looking at what we're talking about in terms of interpreting the face of the language, we're hearing a lot of questions. These are questions that Dr. Canales made no attempt to answer. So again, we have to simply keep going back to this issue is if you want to have the commercial speech exemption apply, you bear the burden of proving that. And Mr. Busby didn't have to say anything in response, but did. And I respectfully disagree that that neither you nor the trial court could consider the affidavit or the information in it about what is the purpose. That is the only explanation. But Dr. Canales never came up with somebody else's opinion about, no, this is not how you do advertising for investigative purposes. There's no opinion, there's no other evidence, there's no other examples, there's absolutely no evidence whatsoever that says that the advertising that was done to obtain information about persons with knowledge was not done for that purpose. No evidence whatsoever.
Are you suggesting that there would be a necessity to have an expert opinion, or does it necessarily have to be an expert?
Well, they're trying to make it an expert opinion. I don't think it's necessary initially, because the first thing we do is look at the face of the advertising. All we've heard so far is a lot of conjecture. Unlike the Miller-Weisbrod case, Mr. Busby and his firm deny that the purpose of the advertisements were to obtain additional clients. Pure and simple, that's not the purpose for those. This is consistent with what they have done in other cases in other locations. But if they want to say that, well, there's got to be something else to this, the face of the advertisement does not propose a commercial transaction. It does not say, hi, we're the Busby law firm, we can do a great job for you, we'll get you the best verdict or whatever it may be. And then an actual or potential client of the firm doesn't get the best verdict.
I'm gonna stop you for just a minute, Mr. Walker,
Yes,
because I think we've lost Judge Powell Fox. So if you'll just bear with us.
I thought she looked pretty still.
Yeah, no, it just so when that happens, she'll log back on, and so we will stop argument for just a minute to give her an opportunity to come back onto the panel. If you'll just bear with us. Wait for her. There she is. All right.
Sorry, I got dropped.
No problem. I think I stopped the proceedings as soon as you as soon as you disappeared. Yeah.
Sorry.
All right, Mr. Walker, you may proceed.
Thank you, Your Honor. Justice Powell Fox, I'm not sure where I lost you in that response, but I was trying to say that it's not necessary to have an expert, but you could. And certainly if you're trying to prove if the face of the advertisement itself does not say that this is directed to, we want to represent you, we want you to hire us, you may have a claim, all the usual magic language or buzzwords that we see in this sort of commercial advertising. If you're trying to interpret beyond that, then by all means come up with some alternative to that. Come up with some expert.
Counsel, if I could interrupt you, I mean, you've talked about, the need for Dr. Canales to have some evidence to challenge the affidavit. I'm kind of curious as to what kind of evidence that would be. I mean, let's say you deposed one of the attorneys from the Busby law firm and said, who contacted you? What did they say? Did you sign them up as clients? I mean, wouldn't your client then be in a position to have to say, I'm not going to tell you any of that because it's attorney-client privileged, or it's work product, if they're just simply a witness? It just seems like that kind of sends us into kind of a thicket that raises a whole lot more issues than we presently have.
Well, and I said certainly something that we all appreciate, because if you go into too much detail, then you land in the world of work product for sure. But if you're taking a deposition of the affiant and say, well, what was the purpose of this? What were you doing? What was the information you're trying to obtain. There's a lot of information that could be obtained without delving into work product. This just goes to the issue of if we have to go beyond the face of the advertisement and look into additional information about what is being done, which we may have to do, that will be one avenue of doing that. Or if you have someone who is an advertiser and says, this is not the way you do that. Like, we do this advertising for witnesses all the time. This is the language that's used, and this is what you ought to be using. I think that is something that could be done if it exists. I've never heard of such an expert, but this circles back to the issue of it's supposed to be a very narrowly applied exemption. In order to make the statute work, you have to meet burdens of proof to show its application, and making assumptions and making guesses about meaning are all that we're left with at this point. And we're all sitting here doing this. What does certain things mean? And we have nothing from Dr. Canales to say that the purpose of this, according to an expert or according to a bar or according to any other source, is for nothing other than to obtain additional clients. And so I appreciate the concern about getting into too many other issues, but that's simply, I think, part of the nature of this process when we have what is really a narrow band of advertising for non-commercial attorney advertising for investigative purposes. And that's what this ban falls into. This is what this advertising falls into. And it doesn't meet the requirements of Castleman as advertising about your own services, because that's not what any of these ads that involve Dr. Canales say. None of them say, we do certain things. We want you to hire us. So all of the advertising related to the services, not of the Busby firm, but of Dr. Canales. And Castleman told us that, they made very clear that people may sell goods and services without falling within this exemption. They have to be talking about their own goods and services. That's not what these advertisements do. Regardless of what you think about the primarily engaged in the business of language, when you take a look at the advertisements, they don't say that this is, we are advertising to people what our services are. We're asking questions about investigation of Dr. Canales in broad language, in plural as opposed to singular. That language does fit within this narrow band of investigative advertising. Now, I would want to make a comment concerning how this commercial speech exemption works. Lawyers may do some advertising, whether it's in the old yellow pages, if they still exist somewhere, or somewhere on a banner, and that's part of what they do, just as an adjunct to the services they provide. The same would be true for Joe Plumber or Rosa's Cantina, or Dr. Canales, for that matter, has information out about the services they provide. We can't let the exemption swallow the rule. And that's what Dr. Canales's effort is trying to say, is that if you do anything, if there's any connection of for-profit providing services that results in some public dissemination of information, then you fall within the scope of this exemption. Well, that's not what the exemption was meant to do. The exemption, this language about seller and principally engaged in the business of, is language that comes from Chapter 82 of the Civil Practice and Remedies Code, which relates to the indemnification for sellers and servicers of products in product liability lawsuits. So this exemption is really a retail exemption. So if you're, for example, a car dealer and you're advertising about the cars that you don't make but you sell, and someone brings a DTPA claim, the legislature did not want those cases to fall within the scope of the TCPA. And the legislature, in drafting this language, said if you're primarily engaged in the business of selling or leasing goods or services, you cannot invoke this, as opposed to if it's incidentally yours.
So, Mr. Walker, then you make a distinction between provision of legal services and being like a car dealer selling goods with that argument. Is that, and so the question is, what legal support are you relying upon to shore up this argument that the exemption won't apply to an attorney who's offering legal services?
I'm not making that that point, Your Honor. What I'm saying is that, just following the plain language of the statute, we frankly don't have to get knee deep or neck deep in the issue of the language of primarily engaged, because here all we have to do is take a look at whether Dr. Canales put on the evidence of the type of services that were provided. So, for example, if you have a lawyer who advertises a lot in order to obtain clients who are then referred out to other people, so the lawyer doesn't provide services, that lawyer would probably be, or could be considered at least, to be primarily engaged in the sale of services as opposed to providing services. The same would be true for other sorts of retailers, people who, entities, I'm not distinguishing lawyers from doctors or accountants or plumbers or anybody else. But, this court has thought about that in the Miller-Weisbrod case. What I'm saying is that we don't have to get mired down in that issue if we simply take a look at whether Dr. Canales met his burden of proof. It is his requirement to show how it is that Busby was primarily engaged in selling. In other words, did he conduct any sort of investigation or obtain any proof that the advertising was for the purpose of obtaining clients who were then referred to other people? We know lawyers who do that. But there is no evidence of that, first of all, because there would be no evidence.
So I'm trying to follow your argument, Mr. Walker. So you're saying that if I'm a lawyer, that I don't sell, if I advertise for clients and I keep the clients in-house, I'm providing services, but I'm not selling my services.
Your Honor, the issue, well, the primarily is the issue. Okay, so the legislature uses terms.
Right.
For
I understand.
right? So
I understand.
primarily in selling. So the legislature means for us to use this narrowly. Dr. Canales wants us to think that if by sale you mean that you provide services or goods for a fee or for a price, then that encompasses all of private enterprise. Okay, and so then the exemption has no meaning. What I'm saying is that that Dr. Canales did not provide evidence that what Busby was doing was trying to solicit clients to then refer them out to other people. That's primarily engaged in the sale of services, not actually providing them.
Well, but hold on. If you provide services, you're selling your services. I mean, if Mr. Busby is, let's say that it is an advertisement. He is primarily in providing services. I mean, unless somebody's a nonprofit, I mean, the whole idea of providing services is providing services for fee. I mean, you can sell widgets or you can provide widgets, I guess, or provide. I mean, I think we just normally think of providing services, but obviously you provide services for fee, or you sell widgets, or you provide widgets for fee. It's a very fine distinction that I can't even barely begin to see.
Your Honor, if we just say that using the interpretation that Dr. Canales wishes us to follow means that everyone who does anything for a profit falls within the scope of this exemption. And that's not what the exemption is meant to be. In other words, if you're saying that participating in selling your services or your goods brings you within the scope of the exemption, that renders the language superfluous. But my point is, I understand, Your Honor, but what we have to do, though, is talk about Dr. Canales' burden of proof. And so he doesn't show that the Supreme Court in the Castleman case, 4 years after this court's Miller-Weisbrod case,
Right.
informed us of how we're supposed to look at this. We're supposed to be talking about the advertisement, in order to fall within the scope of the exemption, it has to refer to the defendant services. It has to be aimed at the clients and consumers of the defendant services and not somebody else. Well, here, the advertisements refer to the services of Dr. Canales. They don't say anything about the services that Busby would provide. You have to go to a stretch and a reach.
Well, when you say defendant, you're the defendant in this case. You were the ones who were sued by Mr. Canales, no?
Correct.
Okay, so it's your services we're talking about, not Mr.
Yep.
Canales. Mr. Canales, Dr. Canales is a defendant in another lawsuit.
It is the services of Dr. Canales that are the subject of the advertisements of which he complains. It's not the services of Mr. Busby. There's nothing at all in the advertisement that says we are going to represent you. They talk about receiving treatment from Dr. Roberto Canales. That's the services that are the subject of the advertisement.
Yeah, but that's not the services that the TCPA is referring to. They're talking about an advertisement for Mr. Busby's services. They're not talking about Mr. Canales' services.
If you're to apply the TCPA exemption, that's correct, but that's not what these ads do.
Okay, thank you.
Thank you,
All right,
Honor. My time is up.
Yes. Thank you, gentlemen. We will submit this case today based on your briefs and argument. We appreciate you participating in this discussion. It's been very enlightening. And so thank you again for that. And hopefully those of you, I think it's only you, Chad, who's back in Central Texas. Good luck with everything.
Thank you for that. We're starting to climb out. Our power is back on and we're looking ahead to better days. Thank you.
All right. All right. All right. Thank you very much.
Thank you, Honor.
Thanks.
Bye-bye.